Dealmaking is glamorous, due diligence is not. This is also true for presentations on due diligence, particularly in the after-lunch slot. Let's see what we can achieve. The focus of my presentation is really to describe the general features of a due diligence exercise in the M&A sector, but with a specific focus on transactions in the realm of renewables. This is because transactions in the realm of renewables are due diligence intensive exercises. And it's really, from my point of view, during the due diligence that you can create added value for clients, even more than in a negotiation of the share purchase agreement. This is because we're dealing with a regulated business. Generally speaking, and not surprisingly, due diligence is the activity of gathering and reviewing documents and information related to the target, but of course the methods and the goals change greatly depending on the type of structure, on the type of transaction and the players involved. In general, it's possible to draw a distinction between full due diligence on the whole activity of a business or limited due diligence on a specific area such as tax, etc. Buyer due diligence as opposed to vendors due diligence, which are quite common in this sector for a number of reasons. First of all, because the seller wants to address to the extent possible issues before putting the target on the market. And secondly, because many times it prepares the due diligence report to the benefit of the various bidders in the context of an auction sale. Then pre-acquisition and post-acquisition due diligence. And of course, physical as opposed to virtual due diligence. And virtual due diligence are very common in the sector because, of course, not only they enable the seller to parallelize the process of due diligence for the buyers, but more importantly, because it gives a competitive advantage in that it is possible through IT systems to check who are the bidders that are actually carrying out a due diligence and which are the areas on which the bidders are particularly focusing their attention. The goals are essentially, from a buyer's perspective, of course, to discover material hidden liabilities on one side, but more importantly, to identify the assets, the key personnel, to verify the economic assumptions underlying the price, and also to, of course, get in right the structure of the transaction and the share purchase agreements, whilst, as we said, from a vendor's point of view, the due diligence is mainly aimed at making appropriate disclosures so as to minimize the costs and liabilities of both parties. To achieve these goals, it is very important to have a good start. So the area which should be covered at the beginning of a due diligence exercise are, of course, a general background knowledge of the target company and the business, and this is when the specialist knowledge is important. The details of the transaction, so clearly define whether it is an asset deal or a share deal, what is the perimeter of the transaction. The objectives of the client in acquiring the business, so whether the goal is to enter into a new market or to consolidate a market share, or simply, as it is many times the case with private equity, with infrastructure funds, to secure a cash flow. Then it is important to clearly allocate the roles of the various advisors right from the beginning and the relevant interfaces. And then, of course, how the acquisition will be financed. That has a great impact on the due diligence and the structure of the deal. And finally, the logistics, so the scope of the due diligence report and the timing of the due diligence. From a legal standpoint, the due diligence exercise is a sequence of legal documents, starting from the mandate letter, the instruction letter, where it is clearly defined, or should be clearly defined, the role of the advisor and the respective liabilities and responsibilities. all the way to the due diligence report, going through, of course, the due diligence questionnaire, for which it is important to stress that it is not a one-size-fits-all kind of approach. This is important, brought from a legal point of view, just to, if you let me, you know, if I look it from an Italian law perspective, you know, the various the legislation of the various Italian regions is very different from region to region, and of course then the due diligence questionnaire must be tailored to the area where the project, the assets are located. And secondly, more important, because many times we have experienced in the purchasing pipeline of projects having to deal with relatively unsophisticated sellers, and of course it would be highly inappropriate to send to the sellers a 30-page due diligence checklist. Then there are a number of ancillary documents mainly aimed at securing the confidentiality from a seller's perspective. And finally, the due diligence report, which should not only identify the relevant issues, but also what is the likely exposure of these issues, and possibly suggest remedies and/or mitigants. Typically, the areas covered by a due diligence exercise in the realm of renewables are multiple. And this clearly shows that the due diligence exercise in the renewable sector, it's a multidisciplinary exercise. It's necessary to involve specialists of various areas ranging from corporate law to employment law, tax law, etc. Starting from corporate, of course, the spectrum of the investigation will change greatly depending whether the target is simply a vehicle owning a project or it is a company with a history owning a complex portfolio of assets. But the key area is the area of public law, so permits, environmental, zoning, etc. It's important not only to check that the permits have been duly issued, but also to check on which basis can these permits be challenged or be revoked by the competent authorities. Land rights is an area in which it is very important to join efforts with the technical advisor, because whilst it is of course duty of the lawyers to check the validity of the titles, on the other hand, it is questionable whether it is an area to be investigated by the technical advisor or the legal advisor, the correspondence between the plots of land set out in the permits with the plots of land for which there is a title. And also, it is up to the technical advisor usually to check whether the sites for the land for which a title has been secured are sufficient to build, to operate, and to maintain the relevant asset, the relevant plant. Interconnection, of course, and then offtake, because, well, it's important to draw a distinction between those regimes where there is a secured, a guaranteed offtake, which basically would relieve from the volume and market risk the producer, from other regimes where it's necessary to enter into a VPP or into a PPA. In this case, it's important to check that the PPA clearly mitigates credit risk, counterparty risk, and also that the force majeure and operational aspects are clearly addressed in the PPA. And finally, also it is important to check that change in law is clearly, the change in law risk is clearly allocated. Same goes with incentives, with the incentives regime, regardless whether it is a plant located in Italy or in the States, that doesn't make a difference. It's important to check what is the level of political risk associated with the incentives, on which basis the incentive may be reduced, may be revoked, and whether there are, for instance, constitutional provisions grandfathering in a way the applicable incentive regime. Then the other project contracts, typically EPC contracts and O&M contracts. For these project contracts, the due diligence, the consultants carrying out the due diligence should check whether the completion risk is properly addressed. The same goes with the performance risk, but also it's important to check, in cases the plant has already been built, what kind of warranties, of technical warranties and performance guarantees are available. Whenever the plant has been financed, the relevant plant has been financed, then of course it's necessary to check the financial documentation. The area of particular concern quite clearly are the change of control provisions, on which basis will the lenders give their waiver to the change of control, the prepayment provisions, and also what kind of equity commitments are imposed on the sponsors. And then other areas are, of course, finance, tax, litigation, and other areas of compliance, such as employment, privacy, anti-bribery, and so forth. Once the due diligence exercise has been completed, then the findings must be mirrored in the share purchase agreement. We can draw a distinction between, quite obviously, deal breakers and other issues which enable the buyer and the buyer's lawyer to structure around the problem. Typically, in this area, the deal breakers will have to do with the permits, with the absence of land rights, and with the lack of requirements to benefit from incentives. Sometimes what we have seen, this is something which was quite common in Italian deals, because given the uncertainty of the permitting regime, sometimes it was questionable whether a specific permit was valid or not, and in this case, at times, the buyer has accepted, and the seller, of course, to include a put option right, rather than just making it a deal breaker. Other material issues, which could then be mirrored in the SPA, addressed in the SPA, either in the form of conditions precedent. This is quite obviously the case in which, for instance, there was a minor violation under applicable laws which can be cured before closing, or in case of third-party consent, or other times just when there is a potential liability which is certain or which is likely to occur and whose amount is clearly defined, then it is possible for the buyer either to factor this into the price or to provide for special indemnities which will have a specific regime different from, which will not provide for the typical caps and limitations applicable to general indemnities. But the specific features which we have seen in the sector, in the renewable sector, I would say is, well, number one, the standard of representation, warranties, and indemnities. We see that in being such a regulated business in which it is important to, particularly for a private equity fund, an infrastructure fund, to secure the cash flow, the standard of representation and warranties is usually much higher than in other industrial sectors. And also, it is usually excluded that the due diligence will amount to a disclosure. This is a general trend. Of course, it's not possible to make it a rule, but compared to other industry sectors, this is very much the case. Also, another area, I have already mentioned that, which is important when drafting the share purchase agreement after the due diligence, is to coordinate efforts with the technical advisors. First of all, because the technical advisor role will be very important in drafting the representations concerning technical requirements, such as, just to make an example, the sufficiency, the adequacy of the spare parts of the plant in the warehouse, or the absence of serial defects, etc. Finally, it is quite common in this sector that the lenders will require the buyer's advisor to rely on the outcome of the due diligence report. Well, this is basically it. If you have any question, and I thank you very much for your attention. Thank you.